This is the moment Karen walks into the courtroom like she owns the building. Chin high, paperwork in hand, and an attitude that screams, "I Googled law once." The judge barely gets started before she starts throwing around nonsense legal terms like, "I am not the person," and "I do not consent." School kids are watching this disaster unfold, probably learning more about red flags than the legal system. It's awkward, surreal, and weirdly captivating. You can practically hear the judge thinking, "Not this again." The courtroom's calm turns to confusion fast. Welcome to the sovereign citizen circus, front row seats included.
Court is now calling City of Conneaut versus Amber McHenry, case number 24 TRB 819.
Ma'am,
I'm sorry. I'm just trying to get my stuff situated so it's right here.
Take a seat
I have a
in
question.
this blue chair.
Do I have the
Sit down.
Do I have the same rights?
You want me to hold you in contempt? Sit down. In that blue chair.
Do I have the
Sit down.
rights there?
One more time. Sit down. Now you'll answer my questions. Got it? Did you understand all of the rights and plea options that I explained to you?
No, I do not understand.
Okay. Then I will enter no plea to the charges
I object.
filed against you. Well, let me just explain to you. You are charged, and I do have a signature on the citation which shows you've been served. You are charged with one count of no operator's license, a minor misdemeanor subject to a maximum fine of $150 plus court costs. You also are charged with one count of expired plates, also a minor misdemeanor subject to a maximum fine of $150 in court costs. I will enter no plea to these charges against you. You already have a pending. You already have a pending.
I object.
What do you object, ma'am?
Because I did not enter that plea.
Okay, so you tell me how you would like the plea: guilty, not guilty, or no contest.
First I have to correct the standing, which is I am not the ens legis non debitor. I am the authorized agent to the decedent estate. I am coming in here as the settler, and I want to settle this case.
Now she's digging in with full sovereign flair, announcing she's the authorized representative, and dropping phrases from internet echo chambers like they're spells. Her body language screams defiance, while her words float somewhere between irrelevant and incoherent. The judge tries to keep order, but Karen's convinced she's playing 5D chess while everyone else is reading from a law book. You know it's going bad when even the court reporter starts blinking in Morse code. The judge gives her rope, and she's already building a legal noose with it. We're only a few minutes in, and she's already in over her head.
I have sent in a paper that is my declaration and affidavit of what I want to do, which is to settle the case. I am willing to surrender the person to the court for mutual consideration. I do not want to continue doing this. I don't have anything to do with this. That paper that I signed, which is the summons, is signed v coatis, which is void contract, and I reserved all of my rights on there. So, is the court willing to give me mutual consideration today or not?
I will enter no plea on your behalf to these charges. I've given you 3 plea options to plead.
No, I do not recognize anyone in this court.
Okay, well,
I don't recognize you or the bailiff or anybody else in this court. I do not understand.
I will set this case for a bench trial, and we'll get this set.
I have the right to a trial by jury.
Okay, no you don't, not in this case.
Yes.
Now these are not jailable offenses, ma'am. You don't have a right to a trial by jury in this case. You already have a jury trial scheduled in another case. But then, because you're facing jail time in that case. But in this case, you're not facing jail time, only a fine and court costs.
Anything that is above $25 in a court of law has the right to a jury by trial, which is involuntary. Involuntary can't be violated, basically, is what it means. So I have the right to a jury by trial.
No, you don't.
Of my peers.
No, you don't.
Yeah.
We're going to set it for trial, and you're going to go to the clerk's window, and they'll give you a trial date. Okay? So...
then I'm just going to surrender the person to the court, because I'm not coming back.
I don't know what that means.
You do know what that means.
I don't know what that means.
I am not the ens legis, non de guerre. I told you
I don't know what that
means.
means either, ma'am. I've been practicing law for 36 years, and what you've just said to me has no meaning to me whatsoever.
Karen's back on her feet, again, arguing something about jurisdiction, as if saying it louder makes it more true. The judge is staying calm, but his patience is clearly wearing thin. She invokes rights she doesn't understand and laws that don't apply, while everyone else is stuck in this bizarre hostage situation of logic. She refuses to sit, ignores instructions, and even tries to dismiss the case herself. It's like trying to debate gravity. It won't work no matter how confident you sound. The courtroom isn't a stage, but she's determined to perform. The question is, will she exit gracefully? Spoiler, no.
So,
Great.
yeah.
So
Ma'am, if you don't leave the courtroom, and if you don't go to the clerk's window to get a trial date, I'll have you arrested and hold you in contempt of court.
With what contract?
There is no contract.
I know there's
You're looking at the contract. You're looking at the one who's going to be able to, has the authority to be able to put you in jail and I'll hold you in contempt. So let me say it one last time, because we have other cases to handle today. If you don't leave the courtroom and go to the clerk's window and get a trial date, which is what I'm scheduling in this case, I will hold you in contempt of court and I'll have you arrested.
So, contempt of court for what? What contempt?
For not doing what I'm telling you to do, which is to go to the clerk's window and to get a trial date.
You're the trustee and I'm the beneficiary.
No, there is no trust relationship here.
No, there isn't.
I've drafted many trusts, and there is no trust relationship between the judge and you, the defendant.
Yeah, because
You are not the beneficiary, and nor am I the trustee.
Yes.
Yeah, that's just not how it works, man.
It
Not
is.
how it works.
Suddenly, the scene gets more surreal. Karen introduces herself as if she's not already in the middle of a disaster. She hands over paperwork that means nothing, then mumbles about the living woman, completely convinced this is a mic drop moment. The judge gives her one last out, but she doubles down instead. At this point, it's not legal strategy. It's just theater. Everyone in the courtroom knows where this is headed, and it's not toward a dismissal. You can feel the tension twist into second-hand embarrassment. This isn't a win. It's a warning for anyone who tries to outsmart the law with YouTube videos.
You either go to the clerk's window now and get a trial date, or I'll have you taken into custody now. You got it?
Is this your phone?
Now we meet her backup dancer, a mini Karen who walks in, refuses to answer questions, and stands silently like she's part of a protest. The judge is clearly over it. This second act is somehow more awkward than the first. It's like a sovereign citizen TikTok duo auditioning in the wrong venue. But the judge doesn't play games. She shuts it down fast. The entire room is now tense, baffled, and overrun with delusion. There's no saving this hearing, only surviving it. If this was their big strategy, it's backfired in spectacular fashion. Exit stage left, and maybe rethink your script next time.
All right, this is 242448 SM, the People versus Eric Martin. Mr. Martin, can you tell me your name?
I'm not Roman cystic if that's what you're wondering.
Okay, I recognize Mr. Martin. Mr. Martin, it's my understanding that Mr. Coots, an attorney, defense attorney, attempted to meet with you to go over your rights and that you did not want to meet with him. Is that correct? Yes or no?
Well, at first I did, and then I kind of changed my mind. I'm still, in the sense of not giving you guys the fraudulent presumption that you got jurisdiction over.
Enter Eric Martin, and he's louder, angrier, and somehow even more clueless. He's out on bond, but already back in court after ignoring the conditions he agreed to. And guess what? He's claiming sovereign status, too. He starts rambling about malicious prosecution and harassment, like he's reading from a sovereign Mad Libs book. The judge doesn't flinch. She's heard it all before. Eric demands dismissal, but the only thing getting thrown out here is his credibility. It's courtroom déjà vu, but louder. He came for freedom, but walked straight into a legal buzzsaw.
I don't want to take it, but
So no.
I'm going to get kind of French too because
I'm going to mute you so I can tell you your rights, Mr. Martin. I need you to listen. So here are your rights. You've been brought to court on an allegation of a bond violation. Specifically, you currently have a domestic violence case pending at this court in front of Judge Slavin, and on that case, the complainant is Kirk Martin. There was a no contact provision, and that was one of the conditions of bond, and there is an allegation that on December 14th, so just this weekend, that someone called from the residence of Kirk Martin and indicated you were in the home, and the officers alleged that you were, that they checked and that you had bond conditions out of this court saying you weren't to be near him, and that you were taken into custody, for violating your bond conditions of no contact with Kirk Martin. These are allegations at this time, but they're serious allegations in violation and no contact provision. So do you want me to enter a plea, or do you just want to ramble about jurisdiction? I'm going to ask you to unmute so you can answer my question. Officer Ziegler, I'm sorry, can you unmute? Mr. Martin, you have options, so you understand that's what you're here on. You can plead guilty, not guilty, or you can say nothing, and I'll enter a not guilty plea on your behalf. So to the allegations that you violated the conditions of your bond for purposes of arraignment, how do you plead?
first I want to notify of crimes. Before I get to that, I want to notify of crimes committed against me in the jail here since I've been here, such as criminal harassment.
Okay, I'm going to enter a not guilty plea on your behalf.
I'm not done talking.
Because your answer is non-responsive.
Violating my First Amendment right, freedom of speech. And this whole bond order condition, it violates my due process right to be free at my house, which is based on an unsupported lying allegation by my brother. Therefore, this is all violation of my due process rights. The bond order should have never been done. This is all unconstitutional. The case should be dismissed, and I demand to be dismissed.
All right, so sir, you have a right to a hearing on this matter. You have a right to receive written notice of the violation. You have a right to plead guilty, not guilty, or stand mute. I've entered a not guilty plea on your behalf since your response was non-responsive. You also have a right to contest the charges at a hearing. You do have the right to the assistance of an attorney at all subsequent court proceedings, and you can change your mind at any time, Mr. Martin. You have the right to have that lawyer appointed at public expense if you are unable to afford an attorney, and it's always possible that if the court determines you were able to pay, that you would be required to contribute to that cost. If you continue to proceed without an attorney, you would give up your right to a lawyer's assistance. We will set the hearing. I'm required to set that hearing on that violation. If you are in custody, we must hold it within 14 days of the arraignment, which is 14 days from today, or the court must order you released pending that hearing. If the alleged violation is based on a new criminal offense, that is basis for separate criminal prosecution, I don't have any knowledge that that's the case here. The court could postpone the hearing for the outcome of that prosecution. You have a right to contest the allegations against you. You would have a right to have the evidence against you disclosed. You'd have the right to present at the hearing, or to be present to present evidence, to examine and cross-examine witnesses. The court would only consider evidence that's relevant to the violation, but it need not apply the rules of evidence except those pertaining to privilege. The prosecuting attorney would have the burden of proving the violation by a preponderance of the evidence. If you pled guilty, you'd be giving up your right to a contested hearing. And while this case is pending, you could be, the most severe violation is you could be held pending the hearing, and if found guilty of this violation, you could be held while this case is waiting for jury trial. So those are your rights, Mr. Martin. Mr. Martin, I understand your sovereign arguments. I mean, it's fine. You can make them. I've heard them before. Everyone at this court has heard them. But here's the thing. I can't have you, if there is a no contact order and you continue to violate the no contact order, I can't let you out because you're not listening. And I know you don't think you have to because you don't.
Eric doubles down, and the judge isn't having it. He interrupts constantly, claims the court has no jurisdiction, and starts talking over everyone like volume equals value. At one point, he even accuses the judge of violating his rights without backing it up. It's like watching someone argue with a GPS. No matter how loud he yells, he's still lost. The judge tries to clarify the charges and offer due process, but Eric treats it like a trap. His confidence is blinding him to reality. The louder he gets, the clearer it becomes. He's arguing himself deeper into trouble. And the judge is just letting him dig.
Accordance with the Constitution. And okay.
And deprives him of the liberty right to be home because of an unsupported lying allegation. I'm telling you right now, he told a lie. And I told the prosecutor my brother assaulted me in actuality. First and foremost, he assaulted me. But I have no evidence of it. I don't have him on video evidence. He doesn't have me on video evidence to assault him. So we have my brother saying this, me saying this. We don't know what happened in reality. So the dumb cop should never arrest me. Prosecutors should not be moving forward on this. They're moving forward with it. It's already a malicious prosecution on the prosecutor's part. There's no probable cause because there's no evidence here. Bottom line, we don't know what happened. This violated my due process rights. I'm being deprived of my freedom to be at the house I've been living at for 32 years. The bond order was legally should have never been ordered because it's based on, once again, unsupported lying allegations that has no video evidence, no real evidence to support it. The bond order must be dismissed. I'm supposed to be allowed to go back home where I have a right to be. Doesn't matter how many lies are told.
Let me tell you your bond conditions, Mr. Martin. You're to appear in court as directed. All right, I'll mute you and read them. Whether you like them or not, these are your conditions, sir. So I'll just read them into the record and you can choose to listen or not listen. You're to appear in court as directed. You're not to leave the state without permission of the court. You're not to commit any new crimes while released. You're to immediately notify the court of change of address or phone number. Whether you like it or not, you're not to have any contact with Kirk Martin or the residents where he resides and where this original allegation occurred, which is 9074 Clipper in the city of Taylor. Sir, you cannot purchase or consume alcohol or illegal drugs. You can't possess or have access to firearms. And you have a $2,000 cash bond. I've noted on the file that you're entitled to this hearing forthwith, so the clerks will give you a date forthwith.
By now, the courtroom is a full-blown circus. Eric throws around buzzwords like trespass and contract with no legal context. He's hoping that by throwing every sovereign term at the wall, one might stick. Spoiler: none do. The judge remains calm, her expression barely changing. It's not her first rodeo. She gives him space to respond, but he turns every moment into a platform for sovereign nonsense. This isn't a trial anymore. It's a teachable moment in courtroom patience. And still, Eric thinks he's winning. Delusion is a strong defense, but not a successful one.